of the system. We are all committed to involving community and community members in the implementation and monitoring process. The Justice Administration Department will hold semi-annual meetings virtually until further notice beginning October 2020, and this is now our 4th meeting. At each meeting, a representative of each defendant group and the court monitor must report on implementation of the consent decree, including explicitly identifying areas of success and areas of an improvement. Next slide, please. Harris County's mission is to build a more dynamic, vibrant, and resilient community while being inclusive, equitable, transparent, and in all that we do. Our justice and safety goal here at Harris County is to promote safe, healthy, thriving communities through restorative and evidence-based strategies that foster public trust, prevent violence and trauma, reduce racial and economic disparities, and minimize criminal justice system exposure where at all possible. So the Justice Administration's department, led by Anna, unfortunately, she cannot be here today due to a family emergency, but we wanted to let you know that we are just an independent research department for Harris County, working collaboratively with the Commissioner's Court and criminal justice stakeholders to help fulfill the mission and the vision of the county. Specifically, we are working to advance innovative approaches to justice that are consistent with Harris County justice and safety goals to promote safe, healthy, thriving communities through restorative and evidence-based strategies that foster public trust, prevent violence and trauma, and reduce racial and economic disparities, and minimize criminal justice system exposure where at all possible. So today, we have on the agenda our federal court monitor, Brandon and Sandy. We have our county attorney office representative, Rachel Frazier. From the sheriff's office, we have Major Doherty, and from the county criminal courts at law, we have the one and only Judge Toria Finch. At the conclusion of each of their presentation, you are free to put questions and answers in the chat below. And at the conclusion of the meeting, they'll be able to answer all of those questions verbally. So first up, we have Brandon and Sandy.
Good afternoon. Hi, my name is Sandra Guerra Thompson. I'm the Deputy Monitor for the O'Donnell Consent Decree. I'm standing in today for my colleague Brandon Garrett, who is a professor at Duke University, and he's having a few technical issues. I'm a professor at the University of Houston Law Center, and again, I serve as the Deputy Monitor. I'm honored to do that along with a team of researchers, Dr. Dottie Carmichael at Texas A&M Public Policy Institute, as well as Dr. Songman Kang and others. Dr. Kang is working, he's a professor in Korea, but he works through Duke University. And then there's a whole team of researchers now at A&M University who are working with us as well. So next slide. All right, in addition, we have a group of members of the community who work with the monitor team. We're an independent group of individuals appointed as monitors for the consent decree. So we are, in essence, overseeing the implementation of the consent decree, but to help guide us and give us feedback on community perspectives, we have this incredible team of community leaders. You see their names and their positions on the screen, and we meet with them regularly to discuss various issues that have come to the attention of the monitors, changes in the law, different demographics of the people going through the system, new resources that are being brought to bear to address a lot of the issues. So that group has been very helpful, and we're grateful for their community service. Next. Okay, so what is bail reform in Harris County? In terms of actual changes in the law, and let me, I see my colleague Brandon Garrett on the line, so I will let him take over. Thanks for, glad you could join us, Brandon. So we were just talking about the community working group, but I'll let you introduce yourself and pick up from there.
Oh, sure. Sorry, the Zoom was attached to the wrong email address. So apologies for the delay in seeing you all. And it was wonderful to see so many of the really remarkable and hardworking Harris County officials and stakeholders, some of the members of our community working group, when we were site visiting in person just a little over a month ago. So I'm Brandon Garrett. It's been just a real honor and privilege to work with Sandy in this role, as reporting to the federal judge in the O'Donnell consent decree, along with our other team members, including other researchers at Duke and particularly at Texas A&M. As many of you know, but some of you may be newer to this area, the O'Donnell consent decree is focused solely on misdemeanor cases, and therefore the O'Donnell decree covers only misdemeanors, and it only covers misdemeanors in certain ways. And there is no longer, as there had been before the changes that were adopted in the consent decree and the judicial rule that the judges composed before the consent decree was entered, called Rule 9. Before those changes took place, there was a cash bail schedule, and so typically a secured cash bond was required for most misdemeanors. Now it's somewhat the opposite. Secured bonds can absolutely still be imposed, but for most low-level misdemeanors, persons are released promptly without a hearing. For more serious misdemeanors, as the slide notes, including cases that raise real pointed public safety concerns, like a repeat DUI, a family violence case, folks on outstanding warrants, probation, bond violations, arrestees are not automatically released. They have a bond hearing, and it's a much more robust, typically a much longer bond hearing than we had in the past. In a cash bail schedule, it doesn't take long to figure out what the cash bail amount is. The hearing officer does something quite mechanical, right? You see, oh, the person is charged with theft. I look down the schedule, that's $1,000. That doesn't happen anymore. Hearings don't take place in 30 seconds. There's a much more substantial conversation between the hearing officer and the lawyers about what the right option is for public safety. And so the hearings are more robust. There's a public defender there, and there's a whole panoply of options available, not just up or down, in or out, secured bond or unsecured bond, but also what are the appropriate conditions if a person is released that can assure public safety and comport with constitutional rights and fairness. And so all these things work together. There are certain categories of people who are booked and released. There are these far more substantial and robust bail hearings. And both public safety and fairness were intended to benefit from this entire structure. And that said, Sandy and I did not design this structure. It was the parties to the O'Donnell case that composed this consent decree. Our role is to monitor compliance with it. So let's turn to some of our more recent findings. We could go to the next slide. In terms of particularly eventful things that have happened since we last had a public meeting like this about 6 months ago, there's now a new system for electronic notifications for people to hear about their upcoming court dates, both email, text, and voice notifications. Not both, it's 3 different options. There was a lot of very hard work that went into the IT behind implementing these systems, and they came online late last year. And the idea is that these should be flexible. They should suit what devices people have, but that people shouldn't be, reliant on saving a court notice or reaching their lawyer on the phone. There should be a way that people can independently find out when is my next court date, just like with picking up a prescription or a doctor's appointment. There is pending, part of the consent decree was that outside researchers would provide advice based on research of what else could be done to improve court appearance and to promote people showing up in court. It's bad for misdemeanor defendants to not show up in court. It can harm their cases. It can cause them to fail bond and for there to be additional consequences. Even if it's not willful and you don't have, sort of legal consequences for not appearing, it drags down the system. It makes it harder to proceed with cases expeditiously. It can harm people's cases as well if their case is delayed or prejudiced in some way. We haven't received those recommendations yet. We'll be getting the report from these outside researchers pretty soon in the next couple of weeks, and we'll all be studying it and seeing what we can learn from it. As those of you who've seen our reports know, we have many tables and figures reporting on analyses of data, largely data from the district courts, but some additional sources of data as well. The consent decree has a transparency focus, and so the county is working hard on making data available publicly so people can follow trends in misdemeanor cases on their own and engage with it. And so there's an interactive data portal. A lot of progress has been made towards assembling all this data and putting it together in a way that's understandable. And we expect that quite a bit more progress will be made in the next 6 months. Hopefully it will be ready before too long, so that you won't have to wait for our reports to look at these types of trends. Another outside evaluation is complete. Last summer, the National Association for Public Defense wrote up a report based on both quantitative and qualitative evaluations of the indigent defense system in misdemeanor cases in Harris County. It's a lengthy multi-hundred-page report, many detailed recommendations, and the county and others have been working hard to kind of work through those recommendations and think about what some of the most practical and beneficial options will be to accomplish the goals or to adopt the recommendations that the NAPD made. And so that's also a work in progress, but that report was really informative and has sparked some really promising problem solving around the goal of having the misdemeanor defense system be the best it can be. So next slide. So turning to our specific findings, many of these are familiar to you if you've read our last reports or been to these before, because in large part, the trends that we've been seeing throughout our 2 years in this role remained consistent, with a few exceptions. In general, though, what we've seen over the entire time period that we've served as monitors, and looking back, we have data going back to 2015, is that in general in recent years, we've seen fewer misdemeanor arrests just about every year. There was an even bigger downtick, whatever the opposite of an uptick is, downturn, the year of the pandemic, and then another modest uptick in 2021. But in general, we're seeing fewer people arrested for misdemeanors over time, and also fewer people rearrested. It's just the misdemeanor system has shrunk. Fewer people are being arrested for misdemeanors. There are a bunch of different overlapping explanations for why that may be. It's absolutely not necessarily because of this consent decree. There are other reasons why fewer people are being arrested for misdemeanors, and maybe some combination of fewer people committing misdemeanor crimes, but also diversion programs, and there's a marijuana diversion program. There have been different priorities in terms of police and prosecutors and public safety approaches towards misdemeanors, which has also affected arrest rates and resulted in charges that might have been pursued in the past not being pursued now. In general, most people now experience a relatively short period of pretrial detention. Most people are booked and then released, but even people who are detained for some period of time, you don't see lengthy detention periods like we did in the past. There are still people who are absolutely detained for long periods of time in misdemeanor cases. They tend to be people who have a felony hold, or there's some other reason why they are being detained, or an immigration hold and the like. In our last report, we had seen and observed a real rise in immigration-related holds in misdemeanor cases. That trend has largely disappeared. most likely because of a change in administration, change in sort of immigration related policies concerning holds, very much outside our role in the consent decree, but those larger national policy shifts have affected immigration holds in misdemeanor cases, at least. We also note that in terms of the race and ethnic makeup of people arrested for misdemeanors, that the share of Black individuals arrested for misdemeanors is quite a bit higher than the population in Harris County. What we have seen is that there had been a real race disparity in who was released and who was not. So that there was something about the bail decision making under the old cash bail schedule that was producing race disparities. That disparity has disappeared since Rule 9 and the consent decree took place. But in terms of who is arrested in the first place on misdemeanors, there is this real disparity as compared to the Harris County population. And that's something that we'd like to learn more about and look at policing data to try to study. So let's turn to the next slide and say a few more things about other findings, but we really want to hear from others and hear your questions. I think we've basically talked about this, that in general misdemeanor filings are down, but there was an even larger decline in 2020 and then a small uptick in 2021. In general, though, the pattern has been quite a bit of a decline, about 10,000 fewer misdemeanor cases than we saw sort of pre-consent decree 2015, 2016. It was closer to 50,000 misdemeanor cases a year. Now it's closer to 40,000. That's a big change. That's 10,000 cases a year is quite a bit. Let's turn to the next slide. This really just illustrates the decline from about 50,000 cases a year to 40,000-ish cases a year. We do note that there has been an increase in the smaller number of cases, but it's a real number of cases where there's a co-occurring felony. And by the way, those are the cases where the person is more likely to be detained for a more prolonged period of time in the jail. So next slide. One other big trend that we observed in our last report, but that has certainly continued and deepened, is that more misdemeanor cases are dismissed or have acquittals and do not result in convictions. And that said, many of the cases in 2020 have not yet resulted in some kind of a final disposition, whether it's a conviction or through a guilty plea or a trial or a diversion or a dismissal or acquittal. But the cases that have been resolved are far more than ever before. We've seen this trend towards more and more dismissals in misdemeanor cases. And there are a number of overlapping reasons for that. And the NAPD report discusses that in some detail from last summer as well, based on their observations, both qualitative and quantitative. But we wanted to note that this is a trend which has been sort of building for some time, and it absolutely continues in this most recent report. So this slide, I think we already talked about that the main difference we see in terms of the race and ethnic makeup of people arrested for misdemeanors in the Harris County population is that many more people who are Black are arrested for misdemeanors, and that's something that we'd like to explore more. We talk a little bit more. We began to do some more geographic analysis of sort of the footprint of misdemeanor cases in Harris County. We show how in recent years, misdemeanor arrests have become more concentrated in a smaller group of neighborhoods. They're less sort of spread around Harris County. Whether that sort of concentration of misdemeanor enforcement in a smaller number of neighborhoods accounts for this, or whether there are other factors, is something that we'd like to learn more about. But it certainly stands out, and it's something that's been longstanding in these data. Next slide. We've already talked about this. This is just a graphical illustration of it, that more and more of the cases that are disposed are cases that are disposed through dismissals, some acquittals, but mostly dismissals, since trials are not common at all in misdemeanor cases. But you also see how in this that there are just many more cases where no disposition is observed from last year, which is due to the the delays in cases moving forward. Just cases take much more time to resolve. There's some positive reasons for that and some negative. One positive reason for that is you often saw people pleading guilty in the, under the old cash bail schedule system because they're detained in the jail. They couldn't afford to make bail, and they would plead guilty within a couple of days. They would be out in the community very quickly. Within a few days, they would plead guilty. Often guilty pleas occurred within a very small number of days, and a very large number of misdemeanor cases were resolved that way. That wasn't really, obviously, an airing of the merits or an investigation into what happened or what the right punishment could be. It was very fast. When people no longer have that powerful incentive to plead guilty solely to secure their freedom from, sort of a cash bail amount, that means that a case has to go forward and potentially be litigated. There needs to be discovery examined. There has to be communication with the victims. And obviously that can be a very good thing. We want victims to play a role and to be communicated with. We want defense lawyers to look at the evidence and talk to their client, and for there to be discussion between the sides about what the right outcome is, or potentially a trial if there's a real adverse position about the case. And it's not like every case should be pleaded out. There are different views about whether trials or the plea bargaining system is the right way to do criminal justice in this country. But it's not necessarily the case that super fast justice within hours or days because someone is detained in the jail is the right kind of justice. But that said, the courts have also been affected by not just a system that can produce more fairness for defendants, but it takes more time. Courts have also been affected by terrible, terrible backlogs, first from Hurricane Harvey, but the pandemic it was an incredible amount of work to keep corporate operations going at any level during the COVID pandemic, and the strains and the burdens placed upon court personnel of all types during the pandemic were really quite remarkable, and incredibly hard work was done to keep things moving. But obviously trials could not be conducted for some period of time, and it will take some time for courts in Harris County and everywhere around the country to sort of come out from under the burdens caused by the pandemic. We've already mostly talked about this, that bond amounts tend to be lower. There are certainly cases, though, where there's a hearing and significant public safety issues are aired, and high bond amounts continue to be imposed regularly. The historical data on bond failure we emphasize in our report is not consistent. Judges could have and did have sort of different approaches towards what constituted a bond failure and when to fail someone's bond. The rates rose before this consent decree and then declined, but we don't sort of put much stock in bond failure rates, nor would we want to say that, oh great, bond failure rates seem to have declined. That means people are complying with bond conditions better than they were in the past. There is as well, not only are there these questions about how consistently bond failures were sort of interpreted in the past, but this consent decree replaced the sort of old system for what constituted bond failure with a far clearer set of definitions for court appearance and for the consequences of court non-appearance. The new rules have some additional flexibility to them. They're also designed to be much more consistent from judge to judge, clear to litigants. And those rules have been in place for more than a year now. We are just beginning to look at what data does exist under the new system to get a sense of what we can learn from it. It's not clear how well you can really compare whatever data we're able to look at from the new system to what happened before, given quality and sort of consistency concerns with the data from before. But we are going to try to learn what we can from the data that we have under the new system, and that's one of our goals in the next time period, where there's now more than a year of sort of experience with the new court appearance system, and we'd like to understand how things are faring and be able to report back to you all in terms of what we can learn from the new court appearance system with the new definitions and some new data as well. So next slide, we may be running towards the end of our presentation and our time. We've already talked about this, I think, that there are lots of concerns with the quality of this bond failure data. There has been a decline in terms of the observed data, but we have a new system of court appearance starting in November 2020. Next slide. Like we mentioned early on, we've seen not just a decline in misdemeanor arrests each year, but also rearrests in terms of numbers of people who've been rearrested for a misdemeanor within a year, or whether it's 90 days, 180 days, or a year. We break down repeat arrests in a number of different ways. And these shares have largely remained constant since 2015. We wouldn't want to say that this consent decree has caused a decline in recidivism or repeat offending. It looked like there is a pre-existing sort of decline trend. The trend hasn't gotten worse. It seems to be a consistent trend over time, that we see fewer misdemeanor arrests each year and fewer repeat arrests. So it suggests that largely repeat offending is stable, with this modest decline in the numbers over a year, which may be contributing to this. Any possible explanations, but we note that trend. And here's sort of a table with numbers. I'm not sure how helpful that is. That may be just about the end. Do we have any additional slides to share? Yes, well, this is a really important one. And so the team at Texas A&M, led by Dottie Carmichael, has done some remarkable work, which much more of which has come together. They've been working hard for more than 2 years now to assemble cost data from the different departments in Harris County to look at the different sort of items of cost involved in a misdemeanor case. What is the cost of a misdemeanor arrest? It's a lot more than I thought it would be. A cost of a misdemeanor booking. It's also a lot more than I thought it would be. The cost of having a public defender present at the bail hearing. Not very expensive. I was shocked how few dollars is spent on that. The cost of different pretrial supervision outcomes or sort of processes. How much does it cost to have GPS? How much does it cost? Prosecution costs. We're working on different victim costs or additional defendant costs, but there are good estimates in terms of sort of the Harris County outlay. Detention costs, of course, are a big item. And in general, we describe that an estimated is quite substantial savings generated through this consent decree. And some of that comes through reduced detention time. Some of it is the share of cases with bond hearings has declined. Jail costs are enormous savings. We talk about nearly 3.6 million annual reduction in jail costs. Now, these are all estimates based on cost savings in the misdemeanor system. There are many fewer people booked on misdemeanors in the jail at any time. That's not to say that these costs have been fully realized by the county, in that the jail hasn't become emptied through this. There may be more space for people who are booked on felonies if there were fewer misdemeanors. And this work continues. We're still looking at other aspects of sort of the full set of costs and benefits under this consent decree. We haven't done a full cost benefit analysis yet, but that's what we're working towards. We also note that early on in the pandemic, there was both increased use of cite and release, and also 2B warrants where the person wasn't sort of booked at that time. That meant quite a number of people who, about a 4% decline in arrest rates, people who otherwise would have been booked centrally at the Joint Processing Center who weren't. That pandemic response also generated huge cost savings. It was something that I learned. I hadn't realized that booking is fairly expensive. It involves space in the Joint Processing Center. There's we gained a real appreciation during our last site visit of all the staff and the hard work that goes into running an efficient booking process. And that pandemic response resulted in a noticeable decrease in bookings that year. And instead, cases sort of beginning with a cite and release or a warrant. And there were real tangible cost savings through doing that. that may be the end of our slides. Do we have any others after this? Okay, I think we've basically talked about these slides. I think that's basically it. That's an overview of our most recent report, and we really look forward to others' comments and your questions. Thank you.
Thank you so much, Brandon and Sandy, for that overview. The full report can be viewed on both the Justice Administration's website and the Independent Monitor's website. And we are receiving your questions. We appreciate them, and we will be sure to get to them at the conclusion of the presentations. Please remember to use the question and answer section, and we'll answer all questions. The next up, we have Assistant County Attorney Rachel Frazier.
Thank you, Bree. So my name is Rachel Frazier, and I'm here on behalf of Christian Menifee, who is the elected Harris County Attorney. The County Attorney's Office is working with all of the stakeholders presently to ensure a constitutional and transparent pretrial release and detention system. We're working to safeguard arrestees' equal protection and their substantive due process rights, and to ensure public safety, access to information, and systematic transparency. Next slide, please. The County Attorney's Office continues to provide legal advice, consultation, contract management, and assistance in the ongoing decree obligations, including the NAPD report that Brandon referenced earlier, the Ideas 42 non-appearance study, the text and electronic court notification system, Rule 9 training obligations, and the data reporting and distribution. Next slide, please. The County Attorney's Office will continue working with the stakeholders to implement the NAPD recommendations and Ideas 42 recommendations associated with non-appearance. We'll continue implementing the electronic notification systems and scheduling options, and advising on other matters consistent with the implementation and improvements to pretrial hearings and procedures that facilitate the consent decree compliance. Next slide. The County Attorney's Office, we regularly meet with the monitor and working group and continue to represent Harris County and work towards the effective and enduring policy implementation of the O'Donnell consent decree with the goal of improving justice. Thank you. Bree?
Thank you so much, Rachel. We appreciate your participation in this process. You're always a joy to work with. Next up, we have our Harris County Sheriff's Office Major of Justice Management, Major Patrick Doherty.
Hello, my name is Major Patrick Doherty. I represent the Harris County Sheriff's Department and Sheriff Ed Gonzalez. Our part of the process is to basically process the prisoners. We basically process them through the criminal justice system from the time of arrest through the time of magistration to bonding out. And of course, under the bond reform, there are some people who don't actually see the judge. They do get out of jail in a fairly efficient, quick manner, but it's the responsibility of my staff to ensure that we follow all the rules and all the decisions made through the court process. And if there's any questions regarding the processing of prisoners, please send your questions in and we'll try to answer them. And that's really all I have.
Thank you so much, Major. We appreciate you and we appreciate your participation in this process. Next up, we have Judge Toria Finch, who is going to talk, who represents the Harris County Criminal Courts at Law.
Thank you so much, Ms. Cummings. Good afternoon, everyone. I am Judge Toria Finch. I'm the presiding judge of our county criminal courts at law, basically stating our misdemeanor courts. And so there are 16 of them. I'm sure you all know by this point, this is our fourth meeting, so I don't want to kind of bore you with the basics, but as you know, the county criminal courts at law, the judges were sued in order to dismantle what was deemed to be an unconstitutional wealth-based system that essentially would incarcerate people solely based on their ability or inability to pay. As you've heard from our federal monitors, we actually have been very successful in bail reform. We continue to implement the consent decree and the spirit of it. Some of the accomplishments that were already previously mentioned, because of bail reform, the county criminal court cases in the jail are less than 10% of the total jail population. I think the last I checked, it's slightly above 9,500, with total capacity being somewhere around 10,000 potential inmates in that location. Additionally, with that, there's a significant cost savings for the county. And also we've seen, as Brandon was speaking of, the steady decline of misdemeanor rearrest, especially for those for serious offenses. And I think that's important. I think many times when people talk about bail reform, one, it's confused with the felony courts, and it's really not even about the felony courts. It's about the misdemeanor nonviolent cases. But it's also important that we bring that up about the decline in the rearrest and misdemeanor cases, because there's also at times this misunderstanding that we are intending to compromise the safety of the community, and that's never the case. In fact, we believe that money does not make our community safe. In fact, conditions make our community safe. So what we've done to ensure the safety of the community, as well as the successful implementation of the consent decree, is to work really hard and diligently with our stakeholders, with the pretrial service department, which has been really helpful in ensuring that we have representatives from their office in each one of our 16 courts. So they're called JLOs, the Justice Liaison Officers. And those are important positions, because those are the individuals that monitor the people that are on bond in our court. We understand that at this point in time, because of bail reform, we have a significant number of individuals that are no longer incarcerated, but they're out in the community living their lives. Hopefully, the goal is to be productive citizens, because they're able to maintain their jobs, take care of their families, continue their education, and even some serve in our military and armed forces. Our judicial liaison officers are the individuals that keep the judge apprised of someone's compliance and or lack of compliance. And when you have a person that's solely designated to monitor the individuals in a court, it makes the load and the supervision much more successful and more practical. And so we're happy to know that at least 10 of our 16 courts do have individual judicial liaisons from the pretrial services department. And so we're hoping to have that those positions fully staffed in the coming future. Additionally, some of the things that we're working on moving forward, and Brendan spoke about this, but we are still seeking to review the data and look at the trends and study that to figure out what are the areas where we need most improvement. This is an ongoing process. None of us knew how to do this from the beginning. We just knew that it needed to be done. And so as we continue to work with our monitors and all of our stakeholders, we're trying to identify what are the areas that are needed, where we're needing improvement. And one of the main things that we're trying to focus on is how do we address our non-appearance rates? How do we get people back into the court? And some of the ways that we started doing that, and Brendan has talked about this, is that we've implemented an electronic notification process. It's like doctor's appointments and everything else that we have going on, even travel. You can set or receive a notification reminding you of your appointment. We have that now. And so individuals don't have to rely solely on a piece of paper that likely will get lost or confused in a stack of other papers and maybe even thrown away, arguably, but they are able to receive notifications electronically, either through text messages and or emails. In my own personal life, I find that to be very effective. And so far, I think we're seeing the same. Just to speak practically, I've seen individuals come to court and their appearance was excused, but they wanted to come because they received a notification that they had a court setting. And I just thank them for coming. And that just shows me that that electronic notification process is working. And so that's one thing that we're also doing. Also, we still have the cite and release program. I see some comments in the questionnaire or in the question or chat section. That still exists. We do and would encourage, of course, law enforcement to use that. It is a great tool to get people in and out of the system quickly, as well as assigned to courts without overpopulating our jails. Additionally, we're working with the MAC. I'm excited actually to report that the Managed Assigned Counsel program, also known as the MAC, they are fully incorporated in all of our 16 courts. So what that means is that individuals that request that they have court-appointed counsel, those appointments are coming through the Managed Assigned Counsel program, and they're able to attach to individuals faster. Because what we do know is that when people have lawyers, they're able to at least confer and consult with them about what their obligations are to the court, when do they need to be there, when do they not need to be there, and how to really navigate through the system. So we understand that attaching individuals to their lawyers that cannot afford them as quickly as possible is essential in ensuring that individuals are in court as well when they need to be. We still have the open hours court. That is the program that allows individuals that have missed court for whatever reason, because life happens, right? It happens to all of us. It doesn't stop just because you are in the criminal justice system, and we respect people's lives as well. And so we allow people to come in to court and say, hey, you know what? I missed my court setting. In fact, we encourage it because we would prefer that people not flee from justice, but submit to justice so that we can seek justice on behalf of not only the defendant, but also the victims in the community as well. It really helps everyone, and it keeps our law enforcement partners safe as well. I'm not going to go on too long because I look forward to answering your questions, but I do ultimately want you to know that the state of the county criminal courts at law and bail reform is good. My mother would say good is not right. I should say well, but you get my point. It's working. And so we want to continue to look at the areas that we need to improve. We know that case backlogs is something that's on everyone's mind, but I want to also report to you all that we've been maintaining a 100% or above clearance rate. And just briefly before I close out my presentation, what that simply means is that when we look at the number of cases that are filed, if they're filed here, to meet a 100% clearance rate, whatever we clear, meaning dispose of, whether it's through a trial, a plea agreement, or a dismissal, or some kind of diversionary program, you would have to meet the exact same point as the numbers that are filed. That's 100%. So the same number that are coming in, you're clearing out at the same amount. That's a 100%. But when we go above that, of the number that is filed, that's when we're hitting the backlog. And so I'm happy to report that the county criminal courts at law are very diligent in trying to hit that above 100% backlog so we can tackle those cases that need to go ahead and process through the justice system. And we're doing that by having trials. The county criminal courts have been very diligent about maintaining jury trials, and we're glad to have them even more frequently now. We know how we inherited the backlog through Harvey and the pandemic, but we're looking beyond the reasons why we have it and looking more towards solutions in resolving it. So I'm very proud of my colleagues. And just a shameless plug here, I want to talk about some restorative justice programs that we're working on as well. So our plates are full. We are dealing with bail reform. We are implementing all these programs from the MAC, the open hours court, cite and release, and so many other things. But we also have a new program where the county criminal courts have adopted or created a new program called the Bayou City Community Court. The Bayou City Community Court at this point is focusing on restorative justice opportunities, because we understand that when people come through the system, that many of them come and they have records, or they need jobs, or they need education. And so we've created an opportunity for people to come and see what opportunities are available. We have a resource fair that we're hosting at this, what we call Fresh Start program. We have individuals from the Harris Health Center. We have individuals or representatives from Goodwill, from the food bank, and so many, My Brother's Keeper, so many other county partners. And why is that important? It's important that the criminal court system not only be a punitive measure, but a place of resource, because we also believe that we can help make our community stronger if we make the people in the community stronger. And so that's what this program is designed to do. It would also look to see who's eligible for petitions for non-disclosures on those misdemeanor, nonviolent cases. And so we're really excited about that program. Please look out for it. Please support it. And there's so much more to come beyond bail reform. But I know that's what we're here for. Thank you for attending, and we thank you for your time. I'll pass it back over to you.
Thank you so much, Judge Finch. We appreciate it and all that you do for our courts. So we have had several questions, and some of them have been answered in the chat. So I'll just go from the top. So the first question was, do you have an estimate on when the misdemeanor data portal will be available? And that is a good question. So I just talked to our data team, and by the conclusion of quarter 2, so not very much longer, will the data portal be up and available for use? And then the next question, will there be a breakdown of Latinx people classified under white in the data portal? how the data is classified, there won't be a special section for Latinx. So I think we answered both of those questions. If you have additional, let me know. There were some questions about, do you have a breakdown regarding how many defendants on some type of misdemeanor bond have been charged with murder and other violent crimes? And that was also answered in the chat. Brandon, is there anything additional you would like to add to that?
No, we broke down in our last report a whole set of different FBI index crimes and rearrest for misdemeanors. And we plan to continue doing that. And we didn't set out those tables in the most recent report, but we will absolutely update that analysis as well.
And I believe this was answered too, but I'll go ahead and say it verbally. Do you have a breakdown regarding how many defendants on some type of misdemeanor bond have forfeited their bond and how many motions to revoke bonds have been filed? I'm sorry.
Yeah, on bond failure, we set out those data, and we talked about that in our slides and our presentation a little bit earlier. There has been a real decline in bond failures, well, bond forfeitures, that is. They sort of reached a height in 2018 and then declined. But that said, there are these issues with the data, including that there weren't consistent definitions for what counted as a bond forfeiture or failure during that time period. We have only just started to look at data regarding the sort of the new rules for court appearance and non-appearance and the new data collected under those new rules during this past sort of year and a half. It was December 2020 when the new definitions and rules surrounding court appearance took effect. In terms of motions, that I don't think we've ever received data on. I'm not sure how well it's recorded. It might be the kind of thing where you'd have to look case by case to see whether there was a paper or PDF sort of image of a motion. So that might be really hard to study.
Yeah, and just to add to that a little bit, one of the challenges is that we want to present data that's accurate. And the only way to measure data accurately over time is if you're measuring the same thing every year. So when the consent decree went into effect and it required changes in some of these rules, then it made it really impossible to compare data from the past to data today. And so we do provide some information on it, but with sort of a major caveat that we're really not comparing apples to apples. So you can't make too much of this information. So that's been one of the challenges. And with regard to the question about ethnicity and Latinx people, in our monitoring reports, we have implemented a system to try to parse out that group in terms of the numbers that we present on demographics. That's not done at the county level. And I'm not an expert on the legality of this, but my understanding is that there are legal reasons why the data is presented the way it is, that it goes back to how law enforcement is governed in terms of data collection, which is again done on a consistent basis statewide and nationwide. So it has to do with some of the rules that relate to that. But because we thought it was important to be able to show that group separately, we utilize a process, some software that it enables us to try to have some estimates about that population.
Thank you. All right, Major Doherty, this is a question for you. There was a question on how many people, if any, with misdemeanors have been transferred to LaSalle.
So very few misdemeanors, mostly felons, just because our population is far and wide felons. Also, our criteria to send people to LaSalle is people who have extended court dates. And generally, the misdemeanor court system has a quicker turnaround than a felony court system does. So very few would meet the criteria. I don't have the exact number in front of us, but it would be a very small number of misdemeanors that would have gone to LaSalle.
Thank you, Major. All right, and it looks like Judge is responding for our next question. Are there any laws that prevent cite and release from becoming an ordinance? Judge, were you available to answer that for us?
I apologize, I couldn't find my mute button. I'm not sure if there are any laws that prevent it from becoming an ordinance, but I do know that cite and release is restricted by the Code of Criminal Procedure as to which type of offenses can be considered for cite and release. And I think it's Article 14.02, subsection C and D. I will turn that over to County Attorney Frazier. She may have the answers to whether there's an ordinance or a law that prevents it from being an ordinance. I'm not sure.
I have to agree with what Judge Finch said, but I'm not sure beyond any information that she just provided at this time.
And I meant 14.06. I think I said 02, 14.06 of the Code of Criminal Procedure.
Thank you both. The next question is, when will the county have a cite and release dashboard? And I'm not sure, we can't answer that question. So it would just depend on the Sheriff's Department, the constables, and HPD. So we can't answer that question thoroughly. My apologies. And then the next question is, and the last one for right now, if you have any more, you can keep them coming. Do you have any data on how many defendants currently on misdemeanor bond are also on felony bond? Brandon and Cindy, can you answer that question?
I'm not sure if we have that broken down in our last report. Let me see. I'd have to look back and check. I'm not finding it quickly. I know that is information that's available. We report on cases with an active hold. That's different. We describe cases where we exclude cases with a co-occurring felony. I know it's here somewhere, and I'm not finding it. Oh, I'm looking at the third report. I need to pull open our most recent report. So it's not. Oh, here we go. Okay, I'm sorry. It took me a minute. Well, here's a report of the share of cases where the person was arrested for a misdemeanor and a felony on the same date. There's been a gradual increase, in the share of such cases. There are about 5% of total misdemeanor cases in 2015 through 17, about 8% in 2020. The share then fell in 2021 down to 6%, which is closer to what it had been before. That's in the share of cases. It's a smaller number of cases. And those are the sort of percentages of all misdemeanors. I'd have to look further in to see if we have a table showing the numbers and not just share. So here we go. No, this is a figure that I showed in the slides. It was figure 1 in the presentation. So there are about 3,000 misdemeanor defendants with a co-occurring felony in 2021. There's about 3,000 in 2020. And so there's a more modest, there's basically been a sort of a modest increase each year in the number and share of persons arrested with a co-occurring felony. It looks like just basically every year since 2015, which is as far back as our data goes, there's been an increase of a couple of hundred people in the co-occurring felony sort of category. No particular change in trend. It's just been sort of a steady trend during this entire 6-year time period. Which is interesting, by the way. On a lot of the things that we've been talking about involve steady trends over this entire 6-year time period. The consent decree, Rule 9, these were big changes in terms of the legal rules, but a lot of the data we see shows these more continuous trends, like not sharp changes. It seems like many of the sort of like the the patterns and outcomes develop slowly over time, which probably means that they come from a number of different factors and not just any one particular rule change that accounted for some, disruption in the system. A lot of what we see involves sort of steady trends over time.
Thanks so much. All right, so we have one more question in the queue right now. And the question says, can the consent decree be amended to measure compliance of the 5th, 6th, 7th Amendments in Texas Code of Criminal Procedure 17.151, release because of delay? Anyone want to tackle that one?
I can take a stab at it. This is Rachel Frazier. So I don't know that that would actually have to be an amendment to the consent decree in order to basically collect the data. But I think that 17.151 references release because of a delay after essentially a trial demand. And perhaps Judge Finch can provide more background on that.
Actually, I'll have to look into it and see, but I do agree with you. I'm not sure that it would need to be amended for that purpose. But if you can leave your information in the chat, I'll collect it and we can follow back up with you to make sure that we're giving you accurate responses.
And I did see one more question in the chat from Lucinda. And so the public portal will be available by the end of Q2. So within the next couple of months, you all should be able to access all of that information publicly and be able to download it and do your own analysis as well. So I think at that point, that's all the questions that have been asked. We just want to thank you all for your time. I want to especially thank our panelists. They work really hard. This isn't an easy task. All of you all matter to us. And so Brandon and Sandy have worked tremendously. They came to Houston to visit and to see things in person and to make sure things are working as we were reporting they have been working. Rachel Frazier is on the daily phone calls with me, assuring that we are in compliance of everything. Major Doherty in the Sheriff's Department, and of course, Judge Finch. I've all been working hard to ensure that the consent decree is in compliance and we're doing what we said we're going to do. So thank you so much for your time. Now, I do have an ask of all of you that have joined us today. We want to know how to improve these meetings, and we also want to make sure that your knowledge has increased. So we're going to drop in the chat a survey monkey for you to take at the conclusion of this meeting, and you're also going to get a thank you email with it. I ask that you please take it and send us back the results, and that would be awesome. For all of you that have asked where this information can be found, how can I continue to stay abreast of all of the changes, you can go to the JAD website. There is a tab especially for the consent decree where you can go and you can get all of the documents that were filed, all the legal filings. You can see the first 3 meetings and all of their slides as well. And then tomorrow, this recording and the slides will also be available. And then we also have Facebook, Twitter, and the chat came up. Facebook, Twitter, and also the Monitor website as well. So there's multiple ways that you can stay abreast of what's going on and get in contact with one of us. And that is all that we have for today. Thank you for your time. And again, these meetings are semi-annually. So in October, we'll be back again talking about the progress that has been made and the analysis that have been completed. So thank you for your time, and we look forward to seeing you again in October.